if your Lordship permits, before we start, I would like to read the referral questions unless I take it your Lordship has read them.
You can read it. You read it.
I think
You
I
read it. You read.
Yes. But the referral order is produced at page 2250 of volume 5 of the convenience compilation, though it's a reported order. 2018, we've got a copy of it. 2018 to SCC 645.
2018.
To SCC 645. 2018 to SCC 645. It's also at document 74, page 2250. My Lord doesn't have it. I was just speaking.
That's all.
May I please it, Lord?
Page number 2.
Lord, 2250 at 2252.
Yeah.
Lord, present batch of writ petitions was originally filed to quash and set aside a notification issued by Union of India on 7th January 2016 and to direct the respondents to ensure compliance with this court's judgment reported as Animal Welfare Board of India versus A. Nagarathna, 2014, 7 SCC 547. However, while these writ petitions were pending, the Prevention of Cruelty to Animals Tamil Nadu Amendment Act 2017, which received the presidential assent on 31st January 2017, was passed. Writ petitions were then amended so as to include prayers to set aside the aforesaid Tamil Nadu Amendment Act on several grounds. After hearing the petitioners and respondents for some time, here is the view that these writ petitions need to be authoritatively decided by a constitutional bench of 5 learned judges, as the writ petitions involve substantial questions relating to the interpretation of the Constitution of India. Questions which require reference to a bench of 5 learned judges, apart from other questions raised in the writ petitions, are set out herein below. 1. Is the Tamil Nadu Amendment Act referable in pith and substance to entry 17, list 3 of the 7th schedule to the Constitution of India? Or does it further and perpetuate cruelty to animals? And can it therefore be said to be a measure of prevention of cruelty to animals? Is it colorable legislation which does not relate to any entry in the state list or entry 17 of the concurrent list? 2. The Tamil Nadu Amendment Act states that it is to preserve the cultural heritage of the state of Tamil Nadu. Can the impugned Tamil Nadu Amendment Act be stated to be part of the cultural heritage of the people of Tamil Nadu so as to receive the protection of Article 29 of the Constitution of India? Is the Tamil Nadu Amendment Act in pith and substance to ensure the survival and well-being of the native breed of bulls? Is the Act in pith and substance relatable to Article 48 of the Constitution? Does the Tamil Nadu Amendment Act go contrary to Article 51 AG and 51 AH? It should have been F and G, but it says G and H. And could it be said, therefore, to be unreasonable and violative of Articles 14 and 21 of the Constitution of India? Is the Tamil Nadu Amendment Act directly contrary to the judgment in A. Nagarathna, Supra, and the review judgment dated 16 November 2016 in the aforesaid case, and whether the defects pointed out in the aforesaid 2 judgments could be said to have been overcome by Tamil Nadu legislature by enacting the impugned Tamil Nadu Amendment Act? So these are the 5 questions framed. There are 3 questions that I said.
Mr. Gupta,
Yes.
we put a question as well.
Yes, Lord.
According to you, these amendments,
Yes, Lord.
they are relatable to which legislative entry?
No, Lord, that's the point I was making. Lord, the entry, if at all, will apply, could have applied, would have been entry in list 17 in list 3. But that entry 17 in list 3, if at all. But entry 17 in list 3 relates to prevention of cruelty, not perpetrating of cruelty. Now, we are in a situation, they have gone to take presidential assent because it's list 3, but at the same time, they are invoking list 2 because they realize that they are dealing with creating of cruelty, not preventing of cruelty. And that's the whole purpose. And that is the reason I'm saying it's colorable. And that is the reason the question was also framed in terms of the Nagaraj.
That is the first question. That is the first question.
Yes, sir. Yes, sir. That's the question.
Mr. Luthra,
Yes.
if it is list two,
Yes, sir.
And there is power.
then there is legislative power.
Yes, sir.
If it is relatable to list three, then even that aspect stands cured.
Not on the curing of that aspect.
Why are we trying about which source of that power? Because in both counts,
But I'll give you one.
Unless you have a case, that it falls in list one.
But my case is this. It does.
No, do you have such a case that it falls in list
But
one?
it's list three. There is no case of list one. We are not propounding that case because that is not the matter at all.
whether that's a matter of nomenclature, many times the title of that may not match with what is quoted in that.
Field of legislation.
Yes, of course. Yes, of course.
The field of legislation,
But
that
that's-
you know, what field of legislation, Article 245, 246 gives a power.
Yes.
245 gives a power actually.
Yes.
That's the difference.
But we are not, I must make it very clear. It is nobody's case that it falls within list one. That's not.
It doesn't fall in list one
Yes.
because if it falls in any of the entries, it is a residuary entry. So you don't have that case. So then, irrespective of whether it's list two or list three, the argument based on legislative entry may not.
But
be of
I'll tell your lordship why. They seek to rely on, I appreciate what your lordship says, they seek to rely on list two. Our point is it is not list two. And so far as list three is concerned, perpetration of cruelty, therefore you can't fit it in list three, therefore you don't have competence to enact it. Secondly, Lord, therefore colorable. Secondly, the point
That's why then it will fall in list one.
Lord,
But you don't have a case that it's in list
we're
one.
not saying it's in list one. That's the point.
Then-
And
I mean, that will be, neither here nor
I'll tell your lordship why. Lord, look at the Parent Act. Let's not look at the Amendment Act alone. Where does the Parent Act fall?
First of all, the prevention of cruelty to animals.
Yes, my lord.
To our understanding, to what you
Yes, of course.
The title, of course, as you know, can always be pretty much misleading.
Indeed, my lord.
Be capturing the entire detail by just having a look at it.
Indeed, my lord.
If you come to 11.3, A to E,
Yes, Lord. Lord,
for instance,
yes, of course.
now when you say prevention of cruelty to animals, it is not an absolute idea. For example, it can go to the extent of destruction of stray dogs.
Lord, there are three things which are accepted.
To view-
Science, stray animals or animals which are harmful, and thirdly, food for religious purposes.
In regard to them, cruelty as we understand it is permitted. Or, see, when you kill a
Yes.
stray dog, for example,
Yes,
you are extinguishing life of
yes, no.
animal
Yes,
actually,
ma'am.
because animal has been defined
Yes.
as in a very broad way.
Yes, my lord.
So, if the legislature thinks that if something should be added to that, then as to whether other grounds are available, we are keeping quiet.
Yes.
But to say, when you say that the legislative entry is not there, it's a.
No, Lord, I'm on a slightly different point. Lord. Let's look at, if your lordship looks at it, let's start with objects and reasons of the laws. Start with the statement of objects and reasons first. Let's open the act. Does your lordship have it?
We are only, just telling you.
Raising an issue, not so it can be
that-
addressed.
when you are talking about legislative competence, the deep matter and, the difference even in voidable, with the violation of fundamental rights and lack of legislative,
Yes, of course.
it's still born. Okay.
Yes.
From the case of, so if you say that it doesn't come under list one, very fairly you put it,
That's
then
right.
legislative competence is there.
But the question
As
is,
to whether it is contrary to Nagaraja.
Nagaraja.
The attempted without taking away the basis for the judgment to undo the judgment.
no, that's the separation. No, that's the third argument. That I'll deal with separately.
Third argument.
That I'll deal with separately. No, that's the third argument. So if I may take your lordship straight away to the statement of objects and reasons.
Yeah.
I believe we have the same act, and if we do,
we have.
it's at page 1.
Unnecessary pain, suffering.
But Mr. Vinupal tells me that their argument is going to be that it's just one.
We haven't given you any ideas, people.
No, we have already considered that, Melons, and we will be submitting that there is no entry to which the statute is traceable either in list 3 or list 2.
So
It will be in the.
97.
97.
Then it goes into 97, in which case, Melons, there's no competence in the first place. Grateful, Melons. My apologies for interrupting. I just wanted to clarify to Mr. Gupta.
Thank you. But we have many players, not some right out, some left out, and some center. So I think my friend is playing the center. Now, Lord, please come straight away to that. Please consider the statement of objects and reasons. So the Committee for the Prevention of Cruelty to Animals appointed, as your lordship have it, page 1.
Yeah.
The Committee for Prevention of Cruelty to Animals appointed by the Government of India drew attention to a number of deficiencies in the Prevention of Cruelty to Animals Act 1890 and suggested a replacement by a more comprehensive act. But then they talk about the existing act in this scope. Leave one para and come to besides declaring certain type of cruelty to animals to be offences and providing necessary penalties for such offences and making some of the more serious of them cognizable, the bill also contains provisions for the establishment of an animal welfare board with the object of promoting measures for animal welfare. Provisions is also being made for the establishment of a committee to control experimentation on animals when the government, on the advice of the Animal Welfare Board, is satisfied that it is necessary to do so for preventing cruelty to animals during experimentation. Not whatever is even exempted is controlled. The bill also contains provisions for licensing and regulating the training and performance of animals for the purpose of entertainment to which the public are admitted through sale of tickets. The prevention of cruelty, that's act having been passed, etc., came on the statute. Now come to the title, Lord, an act to prevent the infliction of unnecessary pain or suffering on animals, and for that purpose to amend the law relating to the prevention of cruelty to animals. So the purpose is other than necessary pain. So you have to avoid all unnecessary pain. Now, therefore, those exemptions are carried out, and I'll come straight away. Now, the act in subsection 3 of section 1, when subsection 2, D says what is a domestic animal. Then please come to section 3. In your copy of the act, my lords will get the amendments that have been brought on by Karnataka, Maharashtra, Tamil Nadu, but we'll come to that later. State amendments, section 3. Duties of person having charge of animals. It shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. Now, 4. Establishment of Animal Welfare Board of India for the promotion of animal welfare generally and for the purpose of protecting animals from being subjected to unnecessary pain or suffering in particular. There shall be established by the central government as soon as maybe after the commencement of this act, a board to be called the Animal Welfare Board. And Lord, the functions of the board, of course, are there in section 9, Lord. Please come straight away to section 11. First the title in chapter 3 and then section 11. Cruelty to animals generally. Treating animals cruelly. If any person beats, kicks, overrides, overdrives, overloads, tortures or otherwise treats any animal so as to subject it to unnecessary pain or suffering, or causes or being the owner permits any animals to be so treated, or B is related to employment, C, willful administration of drugs, etc. Now please come to M for a moment straight. solely with the view to providing entertainment confines or causes to be confined any animal, including tying of an animal as a bait in a tiger or other sanctuary, so as to make it an object of prey for any other animal, or incites any animal to fight or bait any other animal. Or N, organizes, keeps, uses, or acts in the management of any place for animal fighting or for the purpose of beating any animal, or permits or offers any place to be so used, or receives money for the admission of any other person to any place kept or used for any such purposes, or O, promotes or takes part in any shooting match or competition wherein animals are released from captivity for the purpose of such shooting, and then the punishment is provided. Now, what is exempted is, please note 3A, nothing in this section shall apply to the dehorning of cattle or castration or branding or nose roping of any animal in the prescribed manner. So there has to be prescription to how it's done. The destruction of stray dogs in lethal chambers or by such other methods as may be prescribed. The extermination or destruction of any animal under the authority of any law for the time being enforced. Any chapter dealt with in any matter dealt with in chapter 4, or the commission or omission of any act in the course of destruction or the preparation of destruction of any animal as food for mankind, unless such destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. So the swan song of the legislation is avoid unnecessary pain or suffering. Now, I'm not, what is excluded here? What
Sure, we just test your argument,
Yes.
by a sort of
Yes, of course.
couple of questions. Supposing instead of Tamil Nadu or the other states bringing about the amendment,
Yes, sir.
supposing Parliament itself had added 11(1)(f) on its own to the Act.
Yes, sir.
That is one scenario.
Yes.
We will take it a little further. Supposing in the original enactment, like the amendment in the present form made by these three states had been incorporated, taking taking stock of the practices you have in these three, and they sort of in the cooperative effort, they said please exempt. So they exempted it. Parliament itself had exempted it at the time when it was originally made, 1960. I just asking you to imagine it.
Yes, of course, we are imagining.
And if you did imagine that, would you then say that Parliament had the power, authority under entry 7 of list 3?
I am not Parliament's
Whether
power.
Gopal is not here, this question we.
Yes, of course.
Equal
And I'll try and answer it in
If that were done, will you still say, no, you have to still go and hunt for entry 97 and that it is not in list 3? I mean, will that not be carrying it too far?
But I don't think. Mr. Venugopal is here.
Yes, fortunately, we thought you had audited.
No, Lord, I'll answer that straight away, Lord. The first issue is, what was the purpose of the legislation? And therefore, can you have provisions which are destructive of the purpose? And what are the exceptions carved out? Now, Lord, just to tell your Lordship, when the Act was brought in, please see section 12 for a moment, as to the nature of practices that
So
were.
how do you answer our question? Supposing Parliament had amended it instead of, because Parliament has power under entry 7. Or will you say Parliament does not have power?
No, Parliament has power to amend it, but the question is not. The question that I'm raising to myself is this. Let's look at entry 17 and what it says. Prevention. Now, can you perpetrate cruelty while preventing it? That, with respect, Lord, is something which I would submit even Parliament can't do, and that's the whole purpose. If my Lord just has noted that, specifically the entry is prevention of cruelty.
See, that becomes a legislative.
That would be perhaps
legislative value judgment. That becomes an area where you have to bear in mind the thin dividing line between the wisdom behind the statute and the legal, aspect about the statute.
Yes,
we are concerned not with the wisdom.
Yes,
if we were there, we would not make this law. It's a different matter.
That's
it. That doesn't permit us to sit in judgment over
absolutely not.
Sovereign power of the legislature.
Yes.
Whereas, if you say, for example, that it is manifestly arbitrary,
not in fact
after the line of judgments has opened up. After the Triple Talaq case, the McDowell case has been revisited, and now we have firmly sort of accepted that position. To say on the one hand that you are doing this for prevention and you do precisely what is. Well, we are just,
Not a lot. I must tell your lordship very candidly, Lord, there are.
that's a different area, that will bring in a different test altogether. But to say that they don't have power is.
Lord, what I'm saying is this. The point that will be supplementarily made is that it is an issue where your lordships have defined certain rights and 21 rights. Now, once those rights are defined, reading into that the fundamental duties and directive principles, even in
That's by a two-tenths bench.
No, Lord, it is, but I'll tell you, lordship.
Animals have Article 21 rights.
Yes, Lord, but there is the issue of personhood is there, and once there is personhood and there are rights, my submission would be to your lordship is, then the question is, how are you going to test this legislation on the anvil of
On a lighter note, if you don't mind.
Yes, of course, not at all. No? It's always.
My brother was. We were just contemplating that night has fallen, and we are in an area which is infested with mosquitoes.
Yes.
So supposing the mosquito is just about to land on you and
Yes.
take what it wants. A mosquito is also an animal.
Yes.
That's a very wide definition.
Yes, of course.
We were just wondering whether we will stand in fear of being convicted under this act, or whether we will do what might be necessary to protect ourselves, or be in a ward which deals with dengue. And we just
Other issues.
We told you that don't take it either as
No, not at all.
because we are also for the protection of the animals.
Yes, of course.
In a manner of speaking. Nobody. Because the Constitution commands us that we should have compassion. That is one of the articles which we are going to rely on. Nobody can say that we will not have compassion. We should have compassion for all living creatures, but it's always a vanity.
Indeed.
When you
There
talk
has
about
to be.
intergenerational equity, when you talk about all the rights, it is always a balance.
Yes. Definitely.
So now the mosquito.
No, Lord, so far.
How will you deal?
No, Lord, as I said, the Act itself provides, as would any legislation, of things which are accepted in relation to necessity and where the balancing has taken place within the legislation. That fine balance exists within the legislation. The question is to be tested is are these legislations part of that fine balance, or are they, as has fallen from your lordships, completely arbitrary and completely having no rationale with the purpose of the Act?
Different argument.
Yes.
We should be clear in our mind what we are saying.
Yes, of course.
Legislative competence is one thing. After the law is made by competent legislature, whether it should have been made, are the three grounds, fundamental rights, any other part of the Constitution violated. These are the two grounds.
Yes, of course. So we're coming to that part. I'll come to that part exactly. Meanwhile, Lord, can we defer the mosquito for a while?
Pardon?
Can we defer the mosquito? Put the mosquito.
Absolutely.
Yes.
And then
Mosquitoes are wise, fellas. They run away before they are spotted.
snakes also. Snakes.
Snakes.
Snakes then,
Rats.
if you are going away from this mosquito, what
Yes.
about snakes? Snake.
Each one of us.
Not snakes, your lordship will follow a different legislation, the Wildlife Protection Act. There you will have
Yeah,
more
going
serious
by the
consequences.
definition of animal.
Animal.
But there it is a more serious
Any
consequence.
living creature other than
No, I'm
the
telling
other
you,
real
lordship.
creature, that is
But there your lordship have more serious consequences. Then you are running into the realm of the Wildlife Protection Act, where the consequences for the snake is much more serious. And that's a different frame, Lord, not to be placed today, but I can place that to your lordship from 39 onwards. Because I have some little understanding of that legislation, Lord. That's a very, very onerous legislation. There was a time, Lord, when I was on the dark side, when I used to be on the other side, but since then, my friends have converted me. So I have from my previous avatar an understanding of that law a bit. There, the way the law, at least in the Wildlife Protection Act, is in a forest, in a nature reserve, you cannot do anything to touch an animal. And the law is very stringent, Lord. In fact, that is to preserve wildlife, Lord, is something which we've amended that legislation Till 72, we had state acts. Once we came into 1972, we had the central legislation. And then even for ivory, which is something which is not elephant ivory, but ivory of mammoth ivory, even that we have banned in this country. So that is a totally, as I said, different realm. So sometimes Lord, one will have to run rather than touch the snake. So Lord, if I may come back to that legislation, my Lord. Lord, you had put to me the issue regarding experimentation. Just keep two provisions in mind. Section 12, which even while holding an animal, a cow is a captive animal or a milk animal, it talks about certain practices which are not to be done. That's the level of sensitivity as the legislation originally contemplated, because there is, of course, a use. There is a use for humans of cattle, and yet there is protection in section 12. So, my Lord, we just have a glance on if any person performs upon any cow or other milch animal the operation called fuka or doomdev or any other operation, including injection of any substance to improve lactation which is injurious to the health of the animal, or permit such operation being performed upon any such animal in his possession or under his control, he shall be punishable with fine which may extend to 1,000 rupees or with imprisonment for a term which may extend to 2 years or with both, and the animal on which the operation was performed shall be forfeited to the government. 13 is, where the owner of any animal is convicted of offence under 11, it shall be lawful for the court, if the court is satisfied that it would be cruel to keep the animal alive, to direct that the animal be destroyed and assign the animal, and to assign the animal to any suitable person for that purpose, and the person to whom such animal is so assigned shall as soon as possible destroy such animal or cause such animal to be destroyed in his presence without unnecessary suffering and any reasonable expense incurred in destroying the animal. And then, Lord, there are provisions, etc., where animals are injured. Now, these exceptions in the Act, there are certain exceptions in the Act which you will find, Lord, in the sense in section 13 for destruction. Then chapter 4, which is very important. Experimentation on animals. Nothing contained in this Act shall render unlawful the performance of experiments, including experiments involving operations on animals for the purpose of advancement by new discovery of physiological knowledge or knowledge which will be useful for saving or for prolonging life or alleviating suffering or for combating any disease, whether of human beings, animals, or plants. 15. Committee for control and supervision of experimentation. So there's a committee. 15A, there's a subcommittee, then there's a staff. The duty of the committees are pointed out in section 17 in extenso, and subsection 2 is important. In particular, and without prejudice to the generality of the foregoing powers, rules made by the committee shall be designed to secure the following objects, namely, that in cases where experiments are performed in any institution, the responsibility thereof is placed on the person in charge of the institution, and that in cases where experiments are performed outside an institution by individuals are qualified in that job and the experiments are performed on their full responsibility. Then experiments are performed with due care and humanity, etc., anesthetics, etc. I won't trouble your lordship with that. 19 is important. Part to prohibit experiments on animals if the committee is satisfied on the report of any officer or other person made to it as a result of any inspection under section 18 or otherwise, that the rules made by it under 17 are not being complied with, or any person or institution carrying on experiments on animals, the committee may, after giving an opportunity to the person or institution of being heard in the matter, by order prohibit the person or institution from carrying on any such experiments, either for a specified period or indefinitely, or may allow the person or institution to carry on such experiments subject to such conditions as the committee may think fit to impose. And then there are penalties to be imposed. Chapter 5 is very important, Lord, and this is crucial. Please keep one factor in mind. In 2011, the government came out with a notification exempting bulls as performing animals. That still continues till date. So on the one hand, We have the central government notification saying bulls are not performing animals. We have Nagaraj, and on the other hand, we have these legislations and their subsidiary rules and regulations. Now, please, 21 is training and exhibition, but come to 22. Restriction on exhibition and training of performing animals. No person shall exhibit or train any performing animal unless he is registered in accordance with the provisions of this chapter as a performing animal. Any animal which the central government may by notification specify as an animal which shall not be exhibited or trained as a performing animal. And then not these states have come out, the 3 states have overly come out with their amendments, basically to take out Kambala, Jallikattu, etc. See, and that's a challenge. Now, there are offenses in 26. Not, please come to 28. 28, 27 first and 28. Nothing contained in this chapter shall apply to the training of animals for bona fide military or police purposes or the exhibition of any animals so trained, any animals kept in any zoological garden or by any society or association which has for its principal object the exhibition of animals for educational or scientific purposes. 28. Saving as respects manner of killing prescribed by religion, nothing contained in this act shall render it an offense to kill any animal in a manner required by the religion of any community. I'm not here again, they brought in 28A, 28A, all 3 of them have brought it there. And my lord, there is 38. Sorry, 38. So 38 provides for rules to be brought out, and that's the power of the central government.
Exception for domestic pet. Because they are also kept confined.
Yes, but that's domestic pets are in 2D.
That is what domestic animal.
Yes, Lord. So domestic animals means any animal which is tamed or which has been or is being sufficiently tamed to serve some purpose for the use of man, or which, though it is neither been nor is intended to be so tamed, has in fact become wholly or partly tamed. So that's the provision for taming.
Training of domestic animals, is there an exemption?
But I'll just 11. But I'm not what the restriction is in, if my lord just comes to 11 for a moment.
Yes, yes. Okay.
E, keeping in a cage. F, chained or tethered. G, being the owner neglects to be exercised reasonably. H, not giving food. I, abandoning the animal. Is so every animal will be covered mutilation, etc. Not you, even domestic animals, pets are protected or covered. I'm not 38 is the power to make rules by the central government, as I was saying. Now, what the states have done is, Maharashtra at least, they've introduced 38B saying that we have the power to make rules. So these are the issues under challenge before your lordship. While you're looking at the legislation, please also look at page number 21. These are the draught animals rules. And kindly just look at page 23. There is a maximum load prescribed. There's number of passengers that can be put in. There are conditions for the number of hours, etc., that they have to be used. The temperature where they have to be kept. How they have to be disengaged after work. And 8 is most important. Use of spiked bits prohibited. No person shall, for the purpose of driving or riding an animal or causing it to draw any vehicle or for otherwise controlling it, use any spiked stick or bit, harness or yoke, spikes, knobs or projections, or any other sharp tackle or equipment which causes or is likely to cause bruises, swellings, abrasions, or severe pain to the animal.
Yeah.
My lord, we also come back to the definition. So large 2A, large bullocks, large buffaloes are covered under these rules. Here. Now, there are also livestock market rules and transportation rules. The transport of animals on foot rules are there, which we.
That is not very relevant.
No, not they will be relevant, but if they apply to these animals, and I'll tell your lordship why. Lord, if my lord is kind enough to see, that relates to cattle specifically. So these are all relating to cattle. Not they will be just. Lord, they will just. 139 are the livestock market rules. Just have a look at that first. 139 of that volume of that same act. Does your lordship have 139? Please note in 2D, calf means a bovine animal under the age of 6 months. E, cattle means a bovine animal including bulls, bullocks, cows, buffaloes, steers, heifers, and calves. Lot, which is at 144,
Yeah.
as to what are the practices that are harmful and cruel, which are prohibited. Lordship will have.
Context of the livestock, the market.
Livestock rod, and then there are transportation of food rules also. I don't want to trouble your lordship necessary with all this. Sorry, my learned friends also want me to point out one two things. Just Lord, kindly just see 14 for a moment at 145. Does your lordship have G? Forcing animals to perform any unnatural acts such as dancing, putting any ornaments or decorative materials on animals. And 15 to C. 15 to C. It shall be the duty of the person in charge of an animal in an animal market to ensure that animal is not or is not be likely to be caused injury or unnecessary pain or suffering by reason of C. The animal being hit or prodded by any instrument or other thing, nose ropes or nose pegs or bits are pulled, yanked and jerked, causing immeasurable pain and suffering or any other cause.
Not in the context of a market, animal market.
Not so even in a market, the point is not.
Market cannot be done. This is what the rules say.
Yes, Lord. So all these, Lord, the whole purpose is that cattle for animals, even in the marketplace, even on foot, there are various sets of rules which exist in the Act. And all of them deal specifically also with cattle, so cattle are included. I don't want to necessarily go into it. Just not keep one note on my note, document 6, my lord, which is make a note of that. I won't trouble your lordship with it. Document 6, those are the, at page 55, first volume, these are the transport of animals on foot rules. And at rule 11, they prohibit the use of whips, sticks, etc. to hasten the place of the walk of an animal. As I said not earlier, we have the performing animals registration rules, of which rules are exempted. The 2011 notification is still in force.
Which is performing at section 21.
Yes, not 21.
Is it on the basis of sale tickets? Are they doing it on the basis of,
But the argument today is being raised is that there is a commercial aspect to this.
So if you read the definition of exhibit and train
Yes, not
in section 21.
yes. In this chapter, 21, Lord.
Yeah.
In this chapter, exhibit means exhibit at any entertainment to which the public are admitted through sale of tickets, and train means train for the purpose of any such exhibition, and the expression exhibitor and trainer have corresponding.
And section 22
Yes.
is connected with 21.
Yes.
So
22 is connected.
the most important aspect about it is that it should be for our public are admitted through sale of tickets. Without that being there, it will not come within the scope of exhibit or train, because training is for the purpose of execution.
That is
But even, Lord, I must tell your lordship, the way it's been read is that the activity itself of training or of putting an animal through training, one part is the commercial gain, but even if there is no commercial
Sale of tickets, whether you are having a case that when these Jallikattu, etc., take place, they actually sell tickets and then people are invited to.
But in fact,
alone, that's attractive.
yes, Lord. So not the
performing animal, no, that is actually defined under performing animal rules.
yes, my lord.
1973.
Yes, my lord.
There, of course, if the public are admitted through sale of tickets,
Yes, Lord. Not
then they will.
Only then it comes.
It is defined. under
Not in
1930.
fact, not the notification that was issued. So there are two parts, as your lordship rightly noted. So exhibit and train is defined, and it says no person shall exhibit or train any performing animal as unless is registered as a performing animal. Any animal which the central government may by notification the Gazette specifies an animal which shall not be exhibited or trained as a performing
So
animal.
the words train or exhibit, until that happens,
Yes.
22 doesn't kick in.
Yes, Lord. So now in this case, Lord, there is an exception created by the center with the central through rules that cattle, bulls and cows are exempted from this 22. They are not performing animals. And I'll show that.
And the expression performing animal, that is defined.
Yes,
It's defined under the rules
yes. We'll just come to that.
at page 29.
Yes,
What exactly is the performing animal?
yes, my lord. It says performing animal means an animal which is used at or for the purpose of any entertainment, including a film or an equine event to which the public are admitted. So not that's performing animal.
Admitted through sale of tickets.
It not means an animal which is used for the purpose of any entertainment. Not
To which?
now. Not it only says entertainment now.
No, page number 29, rules.
I'm coming to that. Oh, I'm sorry. Not your lordship is a different. Yes, my lord. Your lordship is saying performing animal. Yes, what means any animal which is used at or for the purpose of any entertainment to which the public are admitted through the sale of tickets. So, but your lordship is reading the rules of 1973. I was reading the rules of 2001, which are at page 25, document 3. Please have a look at that instead. The registration rules. Please have a look at the registration rules at page 25, first volume, document 3.
Document 3, yes.
Page 25, sir.
Is it here? Volume 1.
25.
Volume 1 is here. 825 volume.
No.
Does your lordship have the 2001 registration rules?
Good.
Lord, these are the 2001 registration rules. Here the definition is each performing animal means an animal which is used at for the purpose of any entertainment, including a film or an equine event to which the public are admitted. And here again, Rule 8 at page 26 has the general conditions and overleaf at page 27, condition number 5 is relatable to inflicting unnecessary pain or suffering. 6 is feeding to compel to perform any trick. 7 is training an animal to act in accordance with his basic natural instinct. It should be not 8 should be pregnant animals or injured animals or sick animals. And 9, of course, is loud noises. And 11 is not to injure them. 14 is again not to keep them in proximity of loud sounds. And 15 is important, that props such as spears, nails, splinters, barbed wires, and such others shall not cause injury to the animal during performance.
Mr. Luthra, something,
Yes,
something
of course.
different,
Yes, of course.
little digression.
Yes, of course.
Just find out these performing animals.
Yes, sir.
Now, I happen to be associated with the production of a documentary.
Yes, of course.
Now, as a producer, you are required to give a certificate that during the film you have not caused any harm or injury to any animal. Now, where does that requirement flow from?
But
Because that is needed for censorship.
yes, but not it is not. That is required not. That would be under not the Censorship Act.
Cinematography Act or censorship.
But
You say, show it to me.
but may I just
You are supposed to
Rule 7.
the producer is
Not Rule 7. Rule 7 is here, no? Rule 7 in this. Prior information for use of performing animals in films.
Now, this is required even if the animal has no, the film has no animals at all,
Yes.
except human.
Yes. Yes, no. Indeed, not. Rule 7. Prior information for use of performing animals in films. Every owner desire of hiring or lending a performing animal in the making of a film shall give prior information in the format as specified by prescribed authority for this purpose to specify the kind of animal, age, physical health, and the nature of performance to be done, the duration of which animal shall be used for, such performance duration and method of training of the animal for such performance and justification for the use of such animal in the film, and such other information as may be required by that authority. And then it has.
Anyway, this may not be anyway.
But this is
we are
by the owner.
we are
This is by the owner. Yes.
We're digressing. That would be perhaps Cinematography Act or something like that.
Yes, but that would be Cinematographic Act. Not, and if I may just point out, 13 is most important at page 29. Prohibition on exhibition and training of specified performing animals. Performing animals whose performance has been prohibited under subsection 2 of section 22 of the Act shall not be trained, exhibited, or trained or exhibited as a performing animal. Now, number, there is a notification in this regard, which is at page 181, volume 1. This was considered in the Raj convenience compilation.
Page 181.
Yeah. Lord, if your lordship has that, this is the 11 July 2011 notification in exercise of the powers conferred by section 22 of the Prevention of Cruelty to Animals Act and in supersession of the notification of Government of India and the erstwhile Ministry of Social Justice dated 14th October 98, except and as respect things done or omitted to be done before such supersession, the central government hereby specifies that the following animals shall not be exhibited or trained as performing animals with effect from the date of publication of this notification, namely bears, monkeys, tigers, panthers, lions, and wolves.
So that requires, I think, the realization of money through sale of tickets.
But
Otherwise, that's the underlying idea.
But may I just point out, under 22,
For circus.
not under 22, once there is a restriction and they are taken out, 22.2, because there's a notification which allows you to, also there are two parts. It has to be a performing animal. If it is a performing animal, then you come to 21 as to the purpose for which it's used. But when 22 says certain animals are not to be performing animals, then there's no question of 21. That's the point I was making. And that is the reason 22.2 is very clear. It says, no person shall train or exhibit as a performing animal any animal which the central government may by notification the official gazette specify as an animal which shall not be exhibited or trained. 22
There
Roman
is no exhibition if there is no sale of tickets.
Lord, if I may say so, Lord, there are two parts.
Supposing, for example, let's give an example. Supposing there is no sale of tickets.
Yes.
People in the village,
Give me another.
people in the village, they get together. Somebody has an animal and they all get together. There is no money realized. Just giving a hypothetical.
Yes, of course, no.
But the animal is being exhibited.
Yes, of
It's
course.
also performed.
Yes, of course.
Will it attract 21 and 22?
Now, Lord, here I may point out what your lordships, Lord, there's a matter which came up through the Kerala High Court, lot of NR case which reached the Supreme Court. There they have specified that it is not only for commercial gain through tickets, but even otherwise. And I'll just place that. That's in the case compilation 484. It's Lord, page number 484, volume 9. In the compilation of judgments compilation. Today is today. Volume 1.
Which page you want?
But this will begin at 484. That's the division bench judgment which traveled to this court.
Volume 2.
484.
Today.
Volume 1.
Of today's.
Judgments. Volume 1 judgments. 484.
Not that. Change this to this. One number.
Right.
And if your lordship is kind enough to come to para number 7.
Yeah.
At 495.
Yeah.
Does your lordship have this?
If it was-
Yes. The petitioners have a further contention.
Yes.
The petitioners have a further contention that the impugned
495.
The petitioners have a further contention that the impure notification is arbitrary as it prohibits training and exhibition of animals only when the public are invited through sale of tickets as specified in section 21 of the Act, whereas it does not prohibit training and exhibition of animals where the public can be admitted without sale of tickets. We are afraid we cannot give our stamp of approval to this contention for the following reasons. Chapter 5 of the Act deals with performing animals. Section 21 defines the word exhibit to mean exhibited at any entertainment to which the public are invited through sale of tickets. Thus, persons who exhibit animals against sale of tickets are covered under this chapter, and those persons who choose to exhibit animals without sale of tickets would fall under section 11 of chapter 3 of the Act, subclause A of subsection 1 of section 11 of the Act makes it an offense if any person beats, kicks, drives, overloads, tortures, or otherwise treats any animal so as to subject it to unnecessary pain or suffering, caused or being the owner permits an animal to be so treated. Once the exhibition of the specified animals is prohibited under subsection 2 of section 22 of the Act on the ground of prevention of infliction of unnecessary pain or suffering by the circus, the same yardstick would have to be applied in the case of a person who exhibits or trains animals for a show where the public is invited without the sale of tickets. So, Lord, that's the principle that was laid down by the Honorable High Court. This matter did travel to this court. And that's at page 499. Ex-judgment. And if your lordships are kind enough to see, Lord, para 8 will refer to the preamble of the Act. 21 and 22 culled out. Page 502. But there was a notification under 1991 where bears, monkeys, etc. were not to be trained. Now, 7 is the thrust of the argument. And I just read it at 502. The main thrust of arguments of the learned counsel for appellants has been that apart from section 22, the notification itself is arbitrary. It has been contended that 22 contains no guidelines on the basis of which the central government can issue a notification banning exhibition and training of any animal. It is also the case of the appellants that Act does not provide for the animals to be taken away by the government once such a notification is issued. The preamble of the Act states that it was enacted with a view to prevent the infliction of unnecessary pain or suffering on animals, and for that the purpose to amend the law relating to prevention of cruelty to animals. Section 11 provides as to what amounts to cruelty to animals generally, and what section 21, 22, 24 are quoted. Para 10. It will be seen that according to section 24, if it is proved to the satisfaction of the magistrate on a complaint being filed that there is any training or exhibition of performing animals which is accompanied by unnecessary pain or suffering, then court has jurisdiction to order the same. To our mind, keeping the preamble of the Act and 24 in view, par under 22 can be exercised only when the central government is of the opinion that training and exhibition of animals in respect to which a notification is being issued for the purpose of preventing unnecessary pain or suffering be caused. In the very nature of things, when animals are used for performance in a circus that requires their training, it is for the government to decide on the basis of evidence on record and after taking into consideration other factors whether training and exhibition of those animals would result in unnecessary pain or suffering being inflicted on them. It is pertinent to note that even with respect to animals whose exhibition and training is prohibited, the Act does not prevent the owner from keeping them as domestic pets. Of course, it is going to be difficult to expect someone to have a lion or tiger as a pet. That apart, it is the welfare of animals which is of paramount consideration, and it is only if the government is satisfied on the basis of material on record that unnecessary pain or suffering is inflicted on an animal during the course of training or at any time when it is exhibited, that a notification under 20.2 is issued, we are therefore unable to agree. So not that's the principle that was laid down. So it's not just commercial gain, but even otherwise than commercial gain is how your lordships have looked at it. We have taken you through the provisions of the Act. May I just take you now through the provisions of the amending Act? Please come to, we can go to the Acts by itself, but we've culled it out of that chart. I give your lordship the compilation, page 7.
Small.
But this is the bunch that I gave your lordship in the morning.
This one, this one.
Not compilation. That's the one I believe your lordship has it.
Impugned amendments.
Yes. Comparative chart of impugned amendments, page 7. Page 7. It's put horizontally. My friends have put mine still vertically,
Yes.
but your lordships have put horizontally for ease. Now, please see the amendments plot. Let's go through them one by one. First, the Karnataka amendment. Section 2AA, bull races or bullock cart race means any form of bull's race, including race of bullock cart, as a traditional sport. So the focus is on tradition, involving bulls, whether tied to a cart with the help of a wooden yoke or not, in whatever name called, normally held as a part of tradition and culture in the state on such days and places as may be notified by the state government. 2DD. Kambala means the tradition, sports, event involving buffaloes, male race, normally held as part of tradition and culture in the state on such days and places as may be notified by the state government. Now, Lord, these are introduced in the central statute, all of this, definition clause. Then look below that, section 3, duties of persons having charge of animals. It shall be the duty of every person having the charge or charge of any animal to take all reasonable measures overly to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. 2 is added. Notwithstanding, in the one bold, anything contained in subsection 1, conduct of Kambala or bull's race or bullock cart race shall be permitted subject to condition that no unnecessary pain or suffering is caused to the animals by the person in charge of that animal used to conduct Kambala or bull's race or bullock cart race, as the case may be, and subject to such other conditions as may be specified by the state government by notification. I'm not overly, if your lordship. Now, Lord, section 11 is on the next page, but the amendment is at page 10.
You are saying that nothing will apply.
Lord, yes, now conduct of Kambala. Lord, just see page 10.
There.
Page 10. Man. F and G have been added.
That's
The conduct of Kambala with a view to follow and promote tradition and culture, ensure preservation of native breed of buffaloes and also their safety, security, and well-being. The conduct of bull races, the bullock cart race, with a view to follow and promote tradition and culture, and ensure preservation of native breed of cattle, as also their safety, security, and well-being. An overleaf lot at page section 22 at page 11, bold portion proviso to 2. Provided that nothing contained in this section shall apply to conduct of Kambala or bull's race or bullock cart race, as the case may be. So in effect, Lord, what you're doing is you are nullifying the notification in which is under 22(2). It's complete destruction of that. And then Lord overleaf. Section 27 is at the bottom, Lord. Overleaf. C and D have been added. Conduct of Kambala with a view to follow and promote tradition and culture and ensure survival of and continuance of native breed of buffaloes. Conduct of bulls race or bullock cart race. Conduct of bulls race or bullock cart race with a view to follow and promote tradition and culture and ensure survival. For 13, 28A has been added, which says savings in respect of Kambala or bulls race or bullock cart race. Nothing contained in this act shall apply to Kambala or bulls race or bullock cart race conducted to follow and promote tradition and culture. Such conduct of Kambala, bulls or bulls race or bullock cart race shall not be an offence under the act. But similar are the other statutes. The only difference, main difference will be that in the right column at page 13 bottom, Maharashtra has introduced 38B, which allows them to bring in rules. That's quoted at the bottom. That's the real distinction. Otherwise, in essence, they're all same, Lord. Some language change, but really the essence is the same, and the principles they choose to rely upon are the same. So the proposition that we are going to put to your Lordship is this. We have the benefit of Nagaraj. If your Lordship permits, I will only put the salient paras of Nagaraj and the review. Our submission is all these three state amendments do not either deal with or prevent cruelty, and they are in the face of Nagaraj, which I will deal with, of course, at a later stage, and they contradict and are destructive of the main objects of the principal central act. In our compilation, we have put down
Bit of a pagination.
No.
So I've just asked him to.
Yes, in our compilation note, we have put down certain cases which have preceded Nagaraj on animals and compassion towards them, and subsequent judgments which have followed Nagaraj. That I will give your Lordship a list of cases. There are by various high courts. Some have sought to expand the principle. Some had followed it, so that I will give separately, but I don't want to trouble you right now with that. Let us just come straight to Nagaraj Puram.
Compilation volume 5.
In the convenience compilation earlier given, document 75, volume 5, page 2256.
It is already there.
Yes.
Not it's there. The SEC copy is there, not at 2256.
It should be, the SEC is much more.
Yes, of course. But it's 2014, 7 SEC 547. 2014, 7 SEC 547. We've given a list of books also. But it'll be more convenient to have the book, not buy bulk it up.
You start.
Yes, number, I'll just tell your Lordship.
Paragraph.
Nagaraj considers
The other act.
the notification of 11 July 2011 banning the use of bulls as performing animals, which I have placed. It deals with the Tamil Nadu Regulation Act of Jallikattu Law 2009. And then there were certain petitions from the Bombay.
It was found to be repugnant.
Yes, please. No, but there is more. There is just repugnancy was one of the aspects. I'm going to show your Lordship what else. I'm not won't trouble your Lordship too much with the basic issues. But please come straight away to para number 15. My lord will note at para 13, the argument for Tamil Nadu was noted.
If you don't mind, just come to paragraph 91 where the directions are set.
Yes, of course.
And then you can do so that we have
Yes.
a better idea.
Yes.
Para 91, 91.
Yes, Lord. 91, Lord. 91 will begin at not it said internal page 601 of the report. We therefore make the following declarations and directions. But 90 actually.
90.
We therefore hold that Animal Welfare Board of India is right in its stand that Jallikattu, bullock cart race and such events per se violate section 3, 11(1)(a), 11(1)(m)(2) of the PC Act, and hence we uphold the notification dated 11 July 2011 issued by the central government. That's the performing animals regulation notification. Consequently, bulls cannot be used as performing animals either for Jallikattu events or bullock cart races in the state of Tamil Nadu, Maharashtra, or elsewhere in the country. We therefore make the following declarations and directions. We declare that the rights guaranteed to the bulls under 3 and 11 of the PC Act, read with 51 AG and H of the Constitution, cannot be taken away or curtailed except under sections 11(3) and 28 of the PC Act. 91.2. We declare the 5 freedoms referred to earlier be read into section 3 and 11 of the PC Act be protected and safeguarded by the state, central governments, union territory, in short the governments, MOEF and AWBI. AWBI and governments are directed to take appropriate steps to see that persons in charge or care of animals take reasonable measures to ensure the well-being of animals. AWBI and the governments are directed to take steps to prevent the infliction of unnecessary pain or suffering on the animals, since their rights have been statutorily protected under 3 and 11 of the PC Act. AWBI is also directed to ensure that rulings of 11(1)(m)(2) are scrupulously followed, meaning thereby that person in charge or care of the animal shall not incite any animal to fight against a human being or other animal or another animal. AWBI and the governments would also see that even in cases where 11(3) is involved, the animals be not put to unnecessary pain and suffering, and adequate and scientific methods be adopted to achieve the same. AWBI and government should take steps to impart education in relation to human treatments of animals in accordance with 90 and inculcating the spirit of 51 AG and H. Parliament is expected to make proper amendment of the PC Act to provide an effective deterrent to achieve the object and purpose of the Act, and for purpose of 11, adequate penalties and punishments should be imposed. Parliament, as it is expected, would elevate the rights of animals to that of constitutional rights as done by many of the countries around the world, so as to protect their dignity and honor. Government would see if the provisions of PC Act and declarations and directions issued by this court are not properly and effectively complied with, disciplinary action be taken against the erring officials so that the purpose and object of the PC Act would be achieved. The TNRJ Act is found repugnant to the PC Act, which is a welfare legislation, hence held constitutionally void, being violative of 254(1) of the Constitution of India. AWBI is directed to take effective and speedy intents to implement the provisions of the PC Act in consultation with SPC and make periodical reports to the government. And if any violation is noticed, government should take steps to remedy the same, including appropriate follow-up action. So, Lord, these were the directions issued in this judgment. Now, let us just come.
We also read para 86.
Yes, of course.
Or rather, you can begin with 84.
Yes.
The reason why we say this,
Mhm.
the fabric, the text on the basis of which the court consider the matter has been altered
Yes, ma'am.
by the amendment read with the rules will have to be decided with reference to what fell for consideration there.
Indeed.
Paragraph 84,
Yes.
85 and 86.
Yes, but I was just going to place that. Lord, my Lord may just see. Not just see 83 as well. 83 as well. Yeah. Section 38 of the PC Act, because there are rules have been made, confers rule-making powers on central government, and in exercise of the rule-making powers, central government made the Performing Animal Rules 1973 and the Performing Animals Registration Rules 2001. And thrust of all the substantive and procedural provisions is welfare and well-being of the animal and the duties and obligations of persons who are in charge of the animals, and also to safeguard the rights of the animals. Section 8(7) specifically refers to animals' basic natural instinct and cautions that the basic natural instinct of animals be protected and be not exploited. 84. The TNRG Act is an anthropocentric legislation enacted not for the welfare of the animals, unlike the PC Act, which is an ecocentric legislation enacted to ensure the well-being and welfare of the animals and to prevent unnecessary pain or suffering of the animals. The State Act basically safeguards the interest of organizers and spectators while conducting the event of Jallikattu. The Act has no preamble, and the statement of objects of reasons of the Act reads as follows. And then statement of objects and reasons. Jallikattu includes Manju Viratu, Urmadu, Vadamadu, or Erudu, Virum Visa. The said function consists of taming of bulls as a part of ancient cultural tradition of the Tamils. The tradition is in vogue for more than 400 years. At present, there is no legislation to conduct the...
86.
Yes, bro. 86. Section 4 deals with the responsibility of the organizer. Section 4(3) provides for double barricade area in order to avoid injuries to spectators and bystanders. The prime consideration is therefore to avoid injuries to spectators and bystanders and not that of the animal. Section 4(4) deals with the fixing of galleries for the spectators to sit and watch the event. 4(6) empowers the Animal Husbandry Department to test the bills to ensure that performance and massacre drugs are not administered. Duties have also been assigned to the district collector under Section 5 to ensure safety of spectators and to see that bulls are free from diseases, not intoxicated, or administered with any substance like nicotine, cocaine to make them more aggressive and ferocious. Section 5, 9, and 10 authorize district collector to give wide publicity to the provisions of the PC Act and the rules made thereunder, and to ensure the presence of animal welfare activists of AWBI during the conduct of the event. Section 7 deals with penalty. It says, whoever contravenes the provisions of this Act shall on conviction be punishable with imprisonment, which may extend to 1 year, or with fine, or with which may extend to 10,000 rupees or more. 11 of the Act, it may be noted, provides for punishment of a term which may extend to 3 months. To that extent, there is inconsistency. I'm not. 87, I'll read. Yes, sir.
87, 80.
I'll read them. 87.
Finally, the court finds that there is a repugnant.
Yes, sir.
That act was a repugnant.
Yes, ma'am. In 89. 89 is that finding that is repugnant. Now, Lord, what it says and what is more important is, and please note 88. 88 is a very crucial precursor to 89. 88 says the PCA Act, especially Section 3, coupled with Section 11(1)(m)(2), as already stated, makes an offence if any person solely with a view to provide entertainment incites any animal to fight. Fight can be with an animal or a human being. Section 5 of the TNRG Act envisages a fight between a bull and bull tamers. That is, the bull tamer is to fight with the bull and tame it. Such fight is prohibited under 11(1)(m)(2) of the PC Act, read with 3 of the Act. Hence, there is inconsistency. But then, in para 89, I want to read that plot. The TNRG Act in its object and reason speaks of ancient culture and tradition and also safety of animal participants and spectators. PCA was enacted at a time when it was noticed that in order to reap maximum gains, animals were being exploited by human beings by using coercive methods and inflicting unnecessary pain. The PCA Act was therefore passed to prevent infliction of unnecessary pain or suffering and for the well-being and welfare of animals and to preserve the natural instinct. Overpowering the performing animal was never in the contemplation of the PC Act. In fact, under 3 of the Act, a statutory duty has been cast on the person who is in charge or care of the animal to ensure the well-being of such animal and to prevent infliction on the animal of unnecessary pain or suffering. PC Act therefore casts not only duties on human beings, but also corresponding rights on animals, which is being taken away by the State Act. the TNRG Act by conferring rights on organizers and bull tamers to conduct Jallikattu, which is inconsistent and in direct collision with 3, 11(1)(a), 11(1)(m)(2), and 22 of the PC Act, with 51 AG and H of the Constitution, and hence repugnant to the PC Act, which is welfare legislation declared unconstitutional by the Now, there are therefore two parts. One is, as your Lordship rightly said, the repugnancy part. The other is that it's completely in collision with the object of the Principal Act. And there is no difference between, in that sense, between what was done by the TNRJ Act and what is now sought to be achieved.
So that
by,
you have to see a little bit of the rules which have
Yes,
been put in place.
Yes, Lord. I'm going to show the rules. I'll show your Lordship the rules as well, Lord. But I must also point out, Lord, this, what is important in this is not twofold. Kindly just make a note of certain other paras which may be of some relevance to your Lordship in this judgment.
Just as an aside, we just want to ask you one
Yes.
question so that you can.
Yes, of course.
It's about cruelty.
Yes.
No, cruelty to animals is ought to be prevented.
Yes.
That is the whole thing. Animals are our sort of friends, brothers,
Yes.
whatever we call it, part of, they have the same rights as we have. Correct?
Yes.
So much so that cruelty in the matter of sport, the matter of entertainment, is ought to be prohibited. Take a case where you have a boxing bout, or you have fencing.
Yes, Lord.
So you know what it means.
But I used to practice judo, Lord, I'm aware, at a serious level. So I'm very well aware. Though, I must tell your Lordship, judo is known as the gentle way.
Near you.
But it's okay.
Facing griffith.
Not, as I said, I did, not now.
Good thing that you told us.
But that was in my past, different avatar.
Same distance.
Different avatar, Lord. That avatar is over.
Coming back to boxing,
Yes.
you know how, they are
I'm aware, Lord.
pain, and they die even inside this. So animals, at least you can say human beings can be treated on par with animals. So what do you say to that?
Lord, choice and lack of choice. That's the difference.
No, but many choice we are also controlling.
But I must
Suppose
tell,
somebody is getting
your Lordship.
intoxicating psychopathic substances. So that choice we regulate.
Yes. Yes, we do, Lord. But I must tell your Lordship, in the sports ring, and I can tell your Lordship from personal experience, one of the peculiar things that at least in the sport of judo is choking somebody by shutting off the blood supply to the brain, which is one way to get an opponent out. And you blank out. You actually blank out and it happens. And it just has to be done at the right level. You don't actually stop the breath. You don't, but it's only stopping the blood supply for a moment.
Oxygen goes.
And you blank out and you come back in a moment and you're revived in a moment. But when you enter any sport willfully, it may even be the sport of, as mild a sport as, let's say,
Kickboxing.
not even squash. The possibility of injury exists, but you've taken a conscious choice of doing that. Adventure sports, of course, is another category altogether, but it's a question of informed choice. And that's what sets us apart of the sports we choose to indulge in. Fencing, being one of them, fencing, God, and they often have those tips at the end so people don't get stabbed too much. But that's really.
So the animals can't make a choice.
Yes, sir.
So can they have liberty?
Now, the issue is this. Liberty.
He asked a question.
I'll answer.
Definite purpose. Article 21 speaks about no person shall be deprived of his life or liberty, save in accordance with the procedure established by law. So if you say that animals have no way, so their brains are not as,
No. There's a slight distinction. The point I was trying to make out is not that liberty is inherent. Liberty is inherent in every living being, whether it be any form of life. That liberty is inherent. And that is not something that is recognized by the Constitution. It's not given to us, but it's something which is inherent in all of us.
Can an animal
Yes, Lord.
For example, we'll just start with the example with my daughter. Does the mosquito have liberty?
Lord, of course,
What is the
Lord.
meaning of Article 21?
Lord, Lord, I would say, Lord, even the
We are
mosquito.
sorry about the mosquito. Actually, we have nothing against it except that it attacks.
Lord, if one lives in Delhi, if one lives in
Yes,
Delhi,
anyone for
it
it.
becomes an issue that one is worried about mosquitoes all the time.
We are from Kochi, so we
So, Lord, the issue is this.
Perhaps closer home might be polo, my lord, where the horse.
Huh?
The game of polo is a closer home, my lord, to the analogies which you know.
Yeah.
They get injured, my lord, the horses.
Take for example horse racing.
Yes, horse
Now, Lord,
racing.
the
You
issue is
take
this.
horse racing. You think the horses enjoy it?
Lord, the distinction is, and here am I saying, we are dealing
Elephant race.
Elephant
Kerala.
Kerala, Lord. Lord, we are dealing with, I'm sorry? Lord, on the elephant race, I must tell your lordship, that's pending another bench, not that matters likely to come up. It's in fact listed next month. So, Lord, the issue is not when we are dealing with the fight or flight response of an animal, of a creature. So when we are inducing fear or inducing fight or flight, then that inherently is cruel. The difference is not, it's not that animals will not fight with each other. There are occasions when, just a minute. There are occasions not when we will find animals even in the wild, which choose, even elephants, tuskers, you will find that they are battling things out. But here is a question where we as human beings are pushing them to exhibit a certain reaction to stimuli, which at the least can be said to be extremely cruel.
That is
for our entertainment.
For our benefit.
For our entertainment.
Our entertainment.
You are
Yes, Lord. My Lord is-
stressing on that.
Indeed, Lord, that's absolutely right.
That is where we'll have to see the rules.
Yes.
We want you to see the rules because we.
But I'll come to the rules.
What is the change that will be brought about in the?
Lord, Lord, I'll take your lordship to rules. All right, Lord, I was just
Because that
thinking,
immediately take us to what.
Lord, I'll take your lordship to the rules straight away.
Yes, let us see what they have.
Yes, of course.
Under the rules.
I'll take you to the rules and I'll come back to, then what I will do is not at a later stage, certain paras of Nagaraj will be illustrated. I'll do that.
Let's see the rules.
Yes, of course, ma'am. Lord, the rules are placed for your lordship's consideration in volume 1 of the convenience compilation. Does your lordship have it?
Yeah.
But this is the abstract at page 148.
Volume 1. Volume 5.
Rules are at 150.
Say for me.
148 first note. Let's have a look at the
Volume one.
abstract.
It's volume 1.
Volume 1, volume.
So let us see the
Page 150.
Yes, ma'am. I just want to place not that first para.
Yes, there is it.
Does your lord, does my Lord Justice both have it? Yes. Page 148, not document 16. Does your lordship have it, Lord? First paragraph. The Prevention of Cruelty to Animals Act was enacted to prevent the infliction of unnecessary cruelty and suffering on animals. The Act also recognized the need to exempt the application of its provisions in certain circumstances. The Honorable Supreme Court of India, in its judgment in Animal Welfare Board of India versus Nagaraj Civil Appeal, has found that the conduct of Jallikattu is violated to the provisions of the Central Act of 1960, particularly sections 311 and 22 of the Act. Considering the vital role played by the event of Jallikattu in preserving and promoting tradition and culture among people in large parts of the state of Tamil Nadu, and also considering the vital role in Jallikattu in ensuring survival and continuance of native breeds of bulls, the government of Tamil Nadu had decided to exempt the conduct of Jallikattu from the provisions of the Central Act. Accordingly, the government have decided to amend the Act. But just pause here for a moment before we go into page 150. Please keep in mind that this is the same argument that was raised, tested in Nagaraj 1 and in the review. Not exactly the same propositions were examined. Nothing new about it. Now, please come to 150. There's the short note. Please see, under subsection 2 of section 3 of the Prevention of Cruelty to Animals Act, as amended by the Prevention of Cruelty to Animals Tamil Nadu Ordinance, the Government of Tamil Nadu makes the rules, not these rules were made under the ordinance, then under the Act. Now, please see 3. Any individual, organization, or group, herein called as organizers intending to conduct Jallikattu in such places and on such days as may be notified by the government under clause DD of section 2 of the Prevention of Cruelty to Animals Act shall inform in writing to the collector of the district. Organizers shall also obtain prior permission from the collector for the persons as well as their bulls for participating in the Jallikattu event. The collector shall ensure that the names and other particulars of participants in Jallikattu are registered. Then Note 3 talks about inspection. 4 talks about having a committee of revenue, animal husbandry. Interestingly, not comprising of officials of revenue, animal husbandry, police and health departments to oversee and monitor conduct and ensure it's conducted in conformity with the rules. 5. The organizers shall ensure that bulls are put to proper test by the authorities of the animal husbandry department and that no performance enhancement drugs, irritants, etc. are administered to the bulls in any form. The collector shall, with the assistance of experts of the animal husbandry department, ensure that bulls are free from any diseases and not intoxicated or administered with substance with the object of making them more aggressive or ferocious. All of this is really not to facilitate the human element when humans come into contact with the animals. 7. A is the rest. B is in the holding area. Each bull shall be provided adequate space to exhibit normal behavior. Each bull shall be provided a minimum space of 60 square feet. Adequate feed and water shall be provided to the bulls and they shall be allowed to perform their normal physiological functions. The owner of the bull shall always be by the side of the bulls to assure psychological safety and security. Bulls shall be under constant monitoring of veterinarians of the animal husbandry department, police personnel to ensure the safety, security, and well-being bulls. T. Bulls shall be thoroughly observed for any physical injuries to the body parts like mutilated ears, fractured tail, etc. by veterinarians of the animal husbandry department. If any injury is found, they shall not be permitted to participate in the event and be sent back. Then Note 4 is examination of the bulls. Bulls shall be compulsorily subjected to veterinary examination by qualified veterinarians of the animal husbandry department. Participating bulls shall be examined for general health conditions by chemical examination. Bulls showing symptoms of fatigue, dehydration, restlessness shall be identified and not permitted to participate further in the event. The bulls shall be specifically examined for possible alcohol abuse, and any animal which is subject to such abuse shall not be permitted to participate in the event. The bull shall be taken to the entry point from where the nose rope shall be undone by the owner, and the bull is let inside the arena. The bull examination area shall be provided with roofing shamiana so as to protect the bulls from rain or sunlight. Arena shall be a 50 square meter area. Bulls have to be embraced. I like the use of the word not embraced. I grown up in a village, not only when they are domesticated are they embraced, not when they are aggressive or in the ring. Embraced by the participants within this 50 square meter area, the participants shall not be permitted to stand in front of the bulls. As they enter the arena, they should also not be permitted to block the exit way for the bulls. Participants shall be permitted to embrace the bulls by their arm and run along with the bulls for 15 meters or 30 seconds or sustain 3 jumps of the bull. Participants shall not hold on to the tail, horns using their hands or restrict the movements of the bulls by holding onto the bull's leg. The participants violating these guidelines shall be liable to be debarred from participating further in the event. 15-meter area shall be liberally strewn with carpet for cushioning effect to prevent any injuries to the bulls or participants.
Ultimately, granting exemption to Jallikattu,
I'm sorry, Lord.
granting exemption to this local festival of Jallikattu, they put certain restrictions in the rules, how this has to be implemented and how you have to formulate
For the
so
benefit of
that, for the
the-
benefit. So that balancing is there, the local festival should also be there. At the same time, there should not be any injury to any animal and whatever the precautions can be
Yes, Lord.
taken care of with the reasonable restrictions.
But in fact, that's the reason I had started by desiring to show to your lordship the way it is done visually. Visually, not the way it is done with that limited area for an animal of that size and with the nature of, let us say, embracing, to use the word of the rules, the embracing is such which is going to lead and has to lead to brutalizing and injuries. That is inherent in the manner, not where an animal is fleeing and you're trying to hold on to it and restrain its movement aggressively. Now, not all of this is very well to say tails will not be injured, tails will not be broken, you will not pull it, and you will only be allowed 3 jumps, you will not block the area. But the reality is that there are animal fatalities, there are injuries to animals, there are human fatalities, and every year, year after year, there are reports to that issue, reports to that effect, that the numbers have risen of the injuries caused both to animals and to humans. So that is the fundamental problem, Lord, with this. And the reason is this. But festivities and cultural festivals are one thing. But cultural festivities, assuming that they are cultural, assuming that we are going to elevate them, because that is something they will have to establish, that it is elevated to a cultural right. That is something which they are now seeking to raise. It was raised and rejected in the earlier round. Now again, it's been sought to be raised in round 2 of the earlier, in the supersession of the earlier round. But having said that, the question really is going to be, can we allow even cultural rights or norms or practices which are contrary to part 3? Can we allow things which are abhorrent to what the constitution holds? Can we allow things which are going to bring about cruelty? Because I was recalling not this morning when I was talking to my friend that wonderful passage in Sachidanand Pandey, Lord 1987, my Lord Justice Chinappa wonderful decision where he says, what does respect for environment or respect for animal life mean to a human being? And that is a very telling passage on how those who live in nature relate to nature, not with brutality. So that's the whole purpose. And when your lordship sees, Lord, this is what I would call glossing over the act of what is happening. These glosses will not take away from the inherent nature of the activity. And when you release this, Lord, this animal into an area where there are going to be people who are trying to hold on to it, what else is there going to be but flight or fight? It is going to resist being held or resist being controlled. And that is exactly, your lordship said not to get into the visual.
That's why you have put all those photographs.
But that's the reason to show you what the sport is. Not under the rules, what is the sport that is being carried out? We are not going to, and I'm not going to get into this issue of anecdotal material, but if you see the sport, it visually, the impact, it's very clear as to what's happening in terms of the size, the space, and these are 2022 photographs. Illustratively, Lord, just look at it. Lordship, on a lighter note, every day when I leave my office at 8 o'clock, I feel like one of these animals because my juniors are trying to catch hold of me for that last question or that last instruction. So I can tell your lordship at that stage at 8:39 when I'm trying to run, it is a flight response. I don't dare fight with them because I have to keep them in good humor, but it is definitely a flight response where I keep telling them, I said, maybe I have a home to go to, can I leave now? And it doesn't often happen. Now, Lord, just have a look illustratively as to what it is. Nothing else. Just look at volume 3, page document 621118, just two visuals. No, I'm not going to show you numbers, anything. Convenience compilation, volume 3. Just to get an understanding of what this is about and the kind of situation we are dealing with in Jallikattu. Please look at page 1122. Volume 3, convenience compilation given earlier, 1122. But at some stage, I would suggest not that when your lordship has these wonderful screens, we should also have the ability of a screen can be put to show the document on the screen in color, because I think the copies your lordship will have is black and white, whereas because I have a soft copy, I want to show a colored copy. So 1122, the goal is that the background between those two pillars, so to speak, and is being brought out from the inner area. Don't bother reading the comments, because my learned friend Mr. Dwivedi took an objection to the comments. I don't want your lordship to read it. Just see what happens.
Ideally, this photograph should be supported by an affidavit.
But this is part of the petition. This is part of the petitions that are filed. It's part, I'm not giving your lordship anything. I can show you from the writ petitions. Lord, there's no difficulty. Just show it on the writ petition.
No, that's okay.
Petition was filed in 2017 and this is of 22. How can it be part of petition?
Sir, we are allowed to file additional applications and affidavits, sir. So it's part of that. Please take it from me. I wouldn't want to get into something. So look at 1122, Lord. Then look at 123. There's a sharp object which is being used to control the bull's action. 1124. There is at the bottom a gentleman with a raised hand. 1125, the crowds. Well, I can, though not the other day, the Honorable the Chief Justice said, if you give your iPad, you may not get it back, but I'm happy to pass it on for your lordship to see.
If you are safe.
But I prefaced by saying I used to practice judo. But this is the color photograph, I'm sorry. 1122.
Testing of the day.
The same thing.
But same thing, 1122, 1123, 1124,
That's right.
and 1127,
That's
1127, 28. So this lot is the sport, which is
So under the rules, they cannot catch the tail, they have to embrace.
So have you, why don't you?
not, it's like that, not, it's like the traffic rules of Delhi, where as we lawyers are not supposed to use our mobile phones, we are not to cut red lights, we are not to rush to reach the court for 10:30 mentioning. So not all those are wonderful rules on paper, but the reality is.
We cannot approach a challenge to constitutional.
Yes, of course.
Rules should be breached.
No, Lord, that's not the approach. But since your lordship put it to me on a lighter
The
note,
question is whether after the safeguards in the 2009 Act, whether there is a substantial change brought about in the rules. That's why a comparison with the Act,
I'll show your lordship straight away.
we'll have to place it side by side. Has it taken away the basic fabric basis for the earlier judgment?
But that they have
What we
not.
have to do.
But that they have not, and I can make that good straight away. Today we give the Tamil
So
Nadu.
looks like, is there any precedent like this, in the US, the rodeo and cowboy or Spanish bullfight? Is there any?
European-
Who's his president, Lord?
European court might have dealt with it.
Regarding bullfighting, there are cases, not
there
the
was-
hold of the judgment itself. They normally
In
like
Spain, there is
Spanish
this-
languages. So there's Supreme Court of Spain law that releases in English the gist of it. That we have, but that we can't.
So my learned friend, Lord, I concur, Lord. There was a ban placed by the government in one region of Spain. Now the Supreme Court has allowed it in one region of Spain.
Catalonia.
Yes, Catalonia. We don't have the copy of the judgment.
So
We will
they
look
have
for,
allowed wherever it is linked with cultural
we will,
traditions, then they allow it.
Lord, we will look for American precedents
Minus
because
budget.
it is, sorry, sir. We look for American precedents because it may be possible that there should be American
That is
precedents.
the rodeo with that
Right.
news.
Yes, rodeo with the news, not there's bullfighting in Mexico. There's also, Brazil, my friends tell me it's illegal as well.
Huh?
Brazil, it is illegal, Brazil.
Brazil.
But we'll give your lordship precedence as to what is the judicial treatment, if we can locate that and trace it. Not an issue. But this is so far.
Reason why I'm sorry for interruption. The reason why I was not objecting to the filing of these photos without affidavit, I learned some fresh petition has been filed in 22, with which the IA has been filed in this, but that apart, Lordship. I have no objection if Lordship permits
The
them to
file-
place it. The point that the objection is for this reason. That now they show, Lord, there is a, somebody holding a stick.
Metal sickle.
But Lordships would have noticed that the spike is upwards, not downwards, other way around. The sharp edge is inside. Why it is there, Lord, when the bull comes in, then the nose rope, what he does is the man, he cuts that. We have some, Lord, videos of that. And if the Lordship will permit, Lord, it can be seen that every time a bull comes, then they put it and they snap it and then it goes into the arena. Now, the trick of the photo is that when they are touching that rope, you take the photo like this and mention that somebody is nudging here. That's the title given. That's the, Lord, unfairness to the court.
I'm sorry, Lord.
If the bull is sitting, they will say photograph shows sitting. They will say it's exhausted, Lord, suddenly and it's sitting down.
I think
It's better to show the video itself, Lord, and then see, Lord, how it is being conducted.
But there's no difficulty, Lord.
Half of the AWPI, we would also like to place the reports which are there of the last events.
See,
But if I may just,
in the event it is in breach of rules, then it's always open to prosecute.
yes.
And this is of a single instance. These photographs cannot represent all the exhibitions or whatever.
1 lakh,
Not the only
11,000
idea.
bulls
If you can
participated.
establish that this is the order
Lord, if I may
and
just,
everywhere the rules are breached, maybe one.
Lord, may I just. say
1
this?
lakh, 11,000, Lord, more than that, the bulls have participated. Now these few photographs, they rather prove, Lord, that
So we are, so we are being invited to interfere with the right of the bull to participate.
Yes, Lord. Now, Lord, if I may just point out, I don't want your lordship to get into, I think my learned friend in saying that there was unfairness to the court was unfair to us because what I said was, we do not want your lordship to get into the contents of those reports. I'm not troubling you, only to show you a visual depiction of what is the nature of the sport. And that one photograph to which my learned friend took exception is not the relevant point. What is the relevant point is that when they are released into that 50-meter pen with a 15-meter span, so to run, there are people climbing over the animal, and there is going to be, if nothing else, not pain and suffering being caused. And if your lordship, and I'll place that older legislation, what I will do for convenience on the other next day is, I will place a comparison of the new rules and the old rules, and it'll seem absolutely similar.
So, yes, you are right. You can examine the change of,
Place it and then see.
with the amendments made,
Yes, Lord.
the change of rules, how they demonstrated. How they demonstrated. But there is one thing, if your 5-6 volumes convert into a convenience volume,
Yes.
and you go on adding 200 more volumes,
No, Lord.
God knows how,
No, Lord,
what is the term of using convenience volumes.
Lord, I must tell your lordship, Lord, sometimes for us, But what happens is sometimes the
There will
law,
be an act called prevention of cruelty to judges.
but I was going to.
Like you spoke about cruelty to senior advocates, but juniors.
I'm going to say that not amounting to cruelty to advocates also.
No, I don't think Mr. Grover.
Yes, yes.
No, Mr. Grover, it's
4 o'clock.
Mr. Grover, it's cruelty to the juniors who have to carry the files, not you and me.
No,
We should be fair.
I avoid that, but
But I was,
not using a laptop.
Mr. Grover, I was remembering a more gentle animal.
Yes, of course.
And some of you might remember. The animal is named the Empress of Blendings.
Yes.
Does it ring a bell in any?
Yes, of course.
PG Woodhouse.
The
Yes, of course.
PG Woodhouse.
Yes, for PG Woodhouse.
Lord Emsworth,
Yes,
the animal
indeed.
who is exhibited,
Exhibited.
but perhaps not ticketed. I was looking into the Nair judgment of Kerala High Court and which came here.
In fact, not on exhibition. About 3-4 years ago, I was in Lord Pushkar. Coincidentally, at the time of the Mela.
Camel.
Not just camel's blood. They had this bull. It was so huge that we were all looking like pygmies before it. So one was concerned as to what had been fed to the animal and what had been done. It was huge. It was absolutely.
There used to be in Shonpur also in Bihar.
Shonpur Mela, not Shonpur Mela.
Around this time of the
Yes,
year.
Lord. Yes, Lord. Shonpur Mela is there, definitely.
But now with the
This is international.
data and marketing
This
rules.
is international there. Even from outside the country.
From where not?
In this place.
Pushkar.
Pushkar.
Pushkar not because horses, because all the
No, it's an international festival.
international fair. Not
People
it's
all
a great tourist attraction.
There's an attraction over there.
Yes.
I have not visited that time.
And so Lord, we continue on Tuesday then?
Tuesday.
Tuesday. No.
I'll take you.